The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. I'm Michelle Hebert, Director of Communications here at Saney's, and welcome to another Lunch and Learn in our ongoing Financial Friday series. Saney's is excited to offer these sessions in cooperation with our corporate partner, AXA. AXA has a long-standing presence in New York, and a large portion of AXA's New York client base is built upon the work they do within the public education system. Through AXA, Saney's members can receive competitive insurance rates and a full array of retirement services, including a complimentary financial profile for Saney's members. We urge you to take advantage of that benefit. Our AXA presenter today is Keenan Miller, a Regional Vice President from AXA from the Vestal, New York area. Before we get started, please note all participants are muted during the session, and this presentation is full of valuable content. It's kind of jam-packed, but we want to keep it at the half-hour promised. So we'll handle questions via email following the webinar. We'll get you that follow-up information at the end. We're also recording this session, and it will soon be available at saneys.org. With that, I'll turn it over to Keenan.
Thank you, Michelle, and thank you for the opportunity to sharing with everyone today. Before we begin, I want to let everybody know that I'm going to be speaking specifically about a document that we have put together called the Family Love Letter. And the Family Love Letter has been a powerful tool for a lot of families. To obtain this document, I want to encourage people to reach out to their local AXA representative. There are there's not a ton of these, and one way to acquire one would be to sit down with an AXA representative and to go through it thoroughly to put yourself in the best position possible. But like Michelle said, my name is Keenan Miller. I live in the Binghamton area of New York. I've been married for 18 years, nearly 18 years, and have 7 children. And so topics like today are very important to myself and many people that I work with. We're going to talk about, like I said, something called the Family Love Letter. It's an important estate planning document, and it doesn't sound very legal, but it is, in fact, not a legal document, but extremely important. The concept of the Family Love Letter was developed by John Scrogan, an attorney practicing in the Atlantic area, and co-authored by Donna Pagano, a CFP. And one of the specialties that John has is estate planning. And over many years, Scrogan has witnessed the confusion that can be caused by the failure to plan, especially failure to ensure that vital information and documents are accessible at the time that a client dies or becomes incapacitated. A time when most families are dealing with a lot emotionally, and this document is something that he put together to help them during that time. Briefly, the Family Love Letter is a compilation of all the information your family will need in the time of your death, or if you should become incapacitated due to illness or injury. Let's go to the next slide here. So just a couple of things to note that, again, this isn't legal advice or a legal document. This is for educational purposes, right? And we understand that everybody's situation is different. And everybody has a unique circumstances, has personal, individual goals that they're trying to acquire. And so that's why it's important to take this information today, but not to put it into perspective that every situation is different, and this is just for educational purposes. So our agenda today, first, is to put the Family Love Letter in context by talking briefly about the purpose of estate planning. What makes it important? And second, I'll introduce the love letter and go over what should be included in it and how it can be used. And then third, instruct you on how to use the Family Love Letter when it's completed. Now, many people don't have a basic will. It's one of the first questions I ask when I sit down with people, and it's amazing that many people don't have a will. And the failure to plan in some part is due to misconceptions. And the first, estate planning, not just for the rich. If you have any assets at all and loved ones who presumably will survive you, then you should have an estate plan. If you're single, you probably still have siblings or nieces, nephews, friends, maybe a favorite charity. Second, estate planning is not just for older people either. Tragedy in the family could come in the form of accidents or illness. It can strike anyone at any time, and we all know that. We all know of people who have died young, and some of them perhaps without any plans in place or even a will. If there's a chance that you may be incapacitated by illness or injury, and let's face it, the chance is probably pretty great that any of us is more comfortable than thinking about, there are estate planning measures that should be addressed. That being said, you're developing an estate plan. It's important to get away from the third misconception, which is exclusively thinking about death and taxes, because if you focus on those two things, you'll be diverted from what should be the real focus. It's the living. It's your loved ones who live on and your legacy to them. You should focus on protecting your family and their lives going forward. Okay, so estate planning is basically for everyone of all ages. Of course, the more assets one has, the more complex the estate plan may become, but everyone should have a plan. Excuse me. So two principal elements of estate planning. Let me take this slide in reverse order. Okay, you should provide all the relevant information concerning your assets, liabilities, your wishes in the event of your death or incapacity. And then you should have to draw up those legal documents that will ensure that your property is passed on or managed and family members are protected according to your wishes. So time and careful thought needs to be devoted to your estate plan. Remember, your loved ones have to live with the results of your planning or your failure to plan, which brings me to the next slide. Without proper documentation in place, a family can be left in confusion upon your death. And that's the short-term consequences. Without a clearly spelled out and legally binding declaration by you, the stage is set for conflict, and any existing family controversies will play themselves out, with your legacy being the battlefield. And new disputes are also likely to arise. So right now, personally, I'm dealing with a personal client whose mother passed away, and he's got two brothers. And they are all together on this. They are all of the same mind. And they're going about this in the right way. And their mother did some pretty good planning. But the fact is there's still a ton of paperwork that they've had to go through, and it's been hanging over their heads for months. And even though all of this has been on good terms, it has still been a struggle. And so if you die without a will, for example, your estate can be tied up for prolonged periods of time. So legal and administrative fees can be exorbitant. It's quite likely that your assets will not be distributed according to your wishes. So additionally, especially for larger estates without careful planning, your estate could be taxed at the maximum, and your heirs could be taxed to the maximum. All right, so not to talk about taxes again, but we've worked a lifetime to build what you have, and you don't want it to be decimated by taxes or unnecessary taxes. You want the maximum to be passed on to your heirs and to the heirs you choose in the proportion you choose. So now that you understand the relevance of estate planning and to recognize the prominent role that it plays in your future, let's discuss the family love letter. It really is just a compilation of all the information your family will need at the time of your death. It's one document that pulls it all together. It's an inventory with contact information of all your financial papers, all your estate papers, all your personal papers. Okay. It will direct or help direct your loved ones. Okay. With that said, we can focus on the family love letter in greater detail here. Simply put, its purpose is to provide information at a time of confusion. A well-developed estate plan can't help your loved ones, cannot help your loved ones if they don't know about it and if they don't know where the document is located. Okay, we're talking about a time of trauma. The last thing that a grieving family or a family trying to cope with gravely ill loved one It's to search for important documents or the many contracts or policies, deeds, decrees, etc., that may be necessary to deal with your death or incapacity and to go forward with their lives. Your spouse or other loved ones should not have to waste time and emotional energy trying to gather material. What's worse is that there could be an asset that they don't know about, an asset that could be lost or perhaps permanently. So, like I said before, you work hard for your family, you love them. That's why this document is called the Family Love Letter. You're putting this together because you do love them, and you want to save them from the confusion and the worry. You want things to be able to process as smoothly as possible. So moving forward, inventory. So I used that before talking about the Family Love Letter. What sort of information are we talking about compiling in this inventory? Well, all of your advisors, financial information. We're looking at insurances and benefits, documents and other information, as well as any kind of attachments or ethical will. Okay, we'll look at each of these categories. And what's coming up is really a series of lists that contain the information and documentation that comprise the Family Love Letter. Many of the documents referred to require storage in a secure location, so remember to include the location of any papers that are not attached to or in the same place as the letter itself. And remember, the more thorough you are, the easier it will be for you and your loved ones later on. Okay, so the first section covers advisors and financial information, and depending on how extensive your financial investments are, this can encompass quite a stack of material. Make a list of all the people who handle various legal and financial matters for you. Include complete contact information for them. Provide descriptions of the investments and strategy and documents for all of your investments, property, and debts that are owed to you. And one thing many people forget about is frequent flyer miles. Read the promotional material and any membership information. A fine print here from the airlines. Policies regarding transferability of frequent flyer miles vary, and transfer of miles may be restricted or not allowed at all. In some cases, a probated will or other legal documents such as a court order and a divorce settlement is required. And this is potentially a valuable asset that is worth looking into. Information regarding all of your credit card accounts as well, you want to take note of. Next, we come to the insurance and benefits section. For example, every type of insurance you carry, all policy information about coverage, premiums, and how premiums are paid. Now think about this. If you have payments automatically deducted quarterly from a bank or charged to a credit card, it's important to provide that information, perhaps house insurance, life insurance policy for a grandchild, or long-term care insurance for a parent. You don't want a bank account closed or a credit card canceled that would result in a policy lapse or default of some kind. For many people, the retirement accounts are their major investment accounts. So you might want to put the IRAs and the 401ks in the investment section. That might also apply to any stock or any other executive benefits. Either way, make sure to include information about options for survivors and where to get it. And many of these tax-qualified accounts can be passed along to your spouse or other beneficiaries to maintain that tax deferral. So the third section covers the documents and other information. Estate planning documents, which we'll focus on in the following slide, play a prominent role in getting your estate in order. And trust documents, also known as personal and family documents, are often necessary to claim benefits or to prevent claims against your estate. Titles and deeds are needed for the disposition of any physical property or goods. If you serve as a guardian or trustee, those papers will be needed to ensure the proper transition of those responsibilities. Your most recent tax returns can help your executor with filing the return necessary to close your estate. And if you own a business, the ownership papers and the buy-sell agreements are crucial to protect both your business and your family. Now that we know what the trust documents consist of, let's talk about the estate planning documents. Right? The will, the personal property disposal list, living will, medical power of attorney, the durable power of attorney. All right, 4 of these, the will, living will, medical, and general powers of attorney, are legal documents. The other, the personal property disposal list, is something you might want to put together to accompany your will. Simply put, it is about what you've earned, and the other is about what you've learned. Okay, let's look at each of the documents individually here. Your will is the financial declaration of how your assets and your family should be treated after your death. Everyone's circumstances are different. There is no one size fits all. Okay. If you try to get by with something general, then the results may be what you did not intend. It may cause serious problems for your heirs. Okay, in the will, you spell out the disposition of your assets. You choose people to make decisions, an executor, trustees, whoever, whatever is applicable. You make provisions for your heirs who are too young or who don't have the mental capacity to manage their inheritance, and you choose people to take care of your minor children. You try to structure your bequests so as to minimize taxes, and above all, you try to provide clear guidelines to avoid or minimize family conflict. Some of these situations may never apply to you, and some of them, like providing for minor children, both financially and custodially, may apply for only a period of time of your life. Which leads me to the point, wills are not for all time and should be updated as your circumstances change, naming maybe grandchildren, for example. And one final point, traditional families, well, when someone dies, there's basically, or most times, no likely question about the legal rights to the inheritance. However, in a domestic partnership, a will is especially important. Without one, it's likely that the deceased parents or siblings who they will stand to inherit. So be sure to consult your legal advisor regarding your personal situation. So the personal property disposal list. Many professionals involved in estate planning can tell their horror stories about sometimes wretched wrangling that can result over family heirlooms and other personal property. It can lead to relatives not speaking for years. Making an updated list can save a lot of grief. If you want a particular child or one of your siblings or a child of theirs or a friend to receive a particular item, write it down. Document these special bequests. Include pictures so there's no doubt what you're referring to. Such a list can be referenced in your will and honored like your bequests, honored like other bequests. Your legal advisor can explain the rules applying in your state. Okay, if you have been married more than once, you may have children by your first marriage who do not live with you, there's something in your house you want to give to any of those kids, document it. Mixed families where you have a combination of siblings and step and half siblings necessitate care in spelling out your bequests. So we turn to the living will. Well, the Supreme Court in the Cruzen decision ruled that in order to be taken off life support, including intravenous nourishment and fluids, the person must have declared his or her desire before becoming incapacitated. It's not just a concern for older people. Remember that Terry Schiavo was in her 20s when she became incapacitated. And for people who remember the Karen Ann Quinlan case back in the 70s, she was in her 20s when she became incapacitated. So no one who witnessed the unfolding of the Terry Schiavo case should have to be convinced in the necessity of putting their wishes in writing by drawing up a living will. Even in situations where your family is in basic agreement, having a living will relieves your spouse or your adult children of the responsibility of making that decision at such an emotionally fraught time. So the medical power of attorney, you choose the person you want to speak for you, other than a spouse or next of kin. Okay, they're able to speak for you when you cannot. Speak for yourself regarding the whole range of medical treatment. You can make your specific wishes known to this person in advance by providing him or her with a medical directive outlining various possible scenarios and what you would want. This document is especially important for domestic partners. Without a medical power of attorney, it's possible that your partner may not even be allowed to visit you in the hospital. So the right to make medical decisions for you would likely go to your parents or siblings. Even in the states that presently recognize civil unions, it's best to be safe and draw up this document. You should consult your legal advisor regarding your particular situation. Now, in many families, a spouse usually automatically assumes the responsibility. However, depending on the complexity of your finances, among other things, your spouse may not be the person best suited for this role. You may have made joint decisions and your spouse is familiar with your assets. If not, then a trusted financial or legal advisor would be a better choice. Here again, it's important to be specific so your chosen power holder really does have all the power you intend. You should also be specific as to when this power will go into effect, what the specific medical conditions or injured state will be considered triggering event. How much time should be allowed to elapse? Okay, all great questions. Here again, this document is especially important for the domestic partners, and without it, the power of attorney or partner may not have any of the legal rights or standing or decisions. After preparing your estate planning and trust documents, you need to fill in some general information. So you need to fill in, okay, the safety deposit boxes, the keys, the combinations, the access to the information to those things, passwords for computers, email, internet accounts, social security number, your driver's license, passport number, all very important information, medical and Medicare information, religious and other affiliations. You know, some of this information may be contained in other documents, but make sure all of these items are listed somewhere. And in the event of your incapacity, your family needs to know your wishes. The location of your living will and any medical directive. They need to know what plans you have in place regarding powers of attorney and guardianships. In the event of your death, many of the items on the list here are things that you probably want to discuss with family members ahead of time. And decisions about organ donation have to be made immediately, so you can carry a card with you. But be sure your family knows your wishes about this. Details about burial or cremation and memorial services must usually be worked out well before financial matters are addressed. So your family should have already access to all of this information. So this final section covers the family history and ethical will. And just as a regular will is a vehicle for passing your material possessions, an ethical will is a way to pass on your philosophical possessions, your values, or your ideas about what's important in life, your wishes for the future. As it says in the slide, this is about intangibles, what's in your heart, not what's in your bank account. For some people, such a statement of values can actually be the foundation for making estate planning decisions. It might lead you to make specific charitable bequests. In other cases, it's a way to transmit personal histories, the way maybe a family Bible is passed from one generation to another. An ethical will can be added to or rewritten when you arrive at a milestone in your life or go through a major transition in circumstances, not just when you're trying to come to the grips with the idea of your own mortality. This is obviously not a required legal document, but such a personal statement from you could mean a lot to your family. You might decide to make your ethical will part of a larger project to gather documents, memories, and written statements or letters from everyone creating a family history. And when everything's being completed with any attachments necessary, what then? Well, who should hold copies? Your spouse or an adult child, your attorney, advisor? What about the safety deposit box? If so, make sure that access information is available. Okay, home safe. If all your information is there. Make sure somebody knows the combination needed. You may want to present the family love letter at a family meeting or perhaps attended by one or more of your advisors. Whether you have a meeting or talk to people individually, using the family love letter as a starting point, you can open a discussion about issues that many people find difficult to broach. A discussion with your family about the contents of this document may alert you to issues and problems that otherwise might cause conflict later on. In conclusion, the creation of the family love letter can be the key to the smooth execution of your estate plan. Everything is listed, everything is accessible, no hunting, no chaos. But there are values to be derived now. You may discover that your papers are incomplete and you have to do some research now to finish the project. This could save you problems during your lifetime. More importantly, when you look at all of your investments and policies and their values, the coverage amounts, and so forth, it may become clear to you that the policy amounts should be increased, that you should step up contributions to a retirement account, that you should consolidate those IRAs, that your beneficiary should be changed, or a variety of other adjustments you can deal with right now. Discussing this material may be a good way to introduce an uncomfortable subject for you and your family. It can help both you and your loved ones begin preparing for future events. It can help make this process an organic, meaningful family activity. Families are connected over time by legacies, both financial assets and family values that pass from one generation to the next. Creating the family love letter can be a way to encourage openness about a whole range of matters affecting your generation and those that follow. I want to thank you all for your time today. We are right at the doorbell here of 30 minutes. I want to encourage again that anyone that has questions, please make sure that Michelle has them and they can be emailed to me and I will follow up directly. And again, if you would like to sit down and go directly through the family love letter, a great estate planning document, please let us know. We will get one of those documents in your hand and walk through it personally with you. Thanks so much for your time. Michelle, I turn it back over to you.
Okay, everybody. By the end of the day, I'll be sending you all an email with the recording of this session. And if you had any questions, you can reply that email back to me and I'll get your questions onto Keenan. That might be the most efficient way to do it, because then you'll have my email. I'll give it to you anyway. It's mhebert, MHEBERT @saneys.org. But you'll be hearing from me soon, and we'll post this on saneys.org. So thanks, Keenan. I think we're all set. Okay, have a great weekend, everybody.